Hey there, and welcome to our segment on the Martial Court.
First things first, you're probably wondering who these creepy guys are standing in front of this clock. These are some atomic scientists sometime during the Cold War showing off one of their new toys, the Doomsday Clock. It's supposed to show us how close we are to nuclear war. You don't want the clock to strike midnight, because then this happens. Every once in a while, these guys get together, move the minute hand around a little bit. Most recently, they moved it a minute closer to midnight. Now, keep in mind, that's after meeting 2 years before that and moving it 1 minute away from midnight. This sounds like a colossal scam, if you ask me, but it makes my point. In terms of symbolism, midnight is important.
This whole idea of the clock striking midnight is nothing new. Of course, there are fairy tales about this, right? What is it? If Goldilocks doesn't eat the porridge before midnight, then she'll turn into a pumpkin or something like that. I mean, this sort of thing is all over children's literature, this idea of midnight being something final. And so the minutes are ticking to midnight for Adams and the Federalists. The people have just stuck it to them good. They are on their way out. But after the election, they have time for a lame duck session. Quack, quack. All right, that's what a duck says. And so a lame duck session is when these lame ducks, these people that are on their way out of office, Adams is a lame duck, as are several Federalists, they get to meet one more time and decide things during this interval between the time when the new president and Congress are elected and when they take office. And so the people have been so awful to them and so stupid to bring these Republicans in, right, that the Federalists have a chance to stick it to the people one last time. And the way that they can do that is through the judiciary. The judiciary branch, whose members serve for life. And because of this counter-revolutionary effort, the Jeffersonian Revolution will never truly be complete. And so the Constitution establishes 3 branches of government. First, the legislative branch, which is by far the most complex. Then the executive branch in Article 2. By the time they get around to Article 3, I don't know if the framers were tired or what, but they decided to be vague here, more vague than they'd been in the past. When it comes to the composition of the judiciary, they left this very open-ended. The Constitution says in Article 3, Section 1, the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as the Congress may from time to time ordain and establish. So from time to time, Congress will get together and they'll establish some courts as they see fit. Let's let them deal with it. So Congress has the power to establish as many or as few federal courts and judges as it pleases. So in 1801, Congress passes the Judiciary Act of 1801, aptly named, which creates 16 new federal judgeships. And so 16 federal judges who will get to interpret disputes concerning the law from a Federalist perspective and make sure that the Jeffersonians are never able to get a full foothold on the federal government. The Republicans derided this act as the Midnight Judges Act. Here was Adams about to turn into a pumpkin, writing off as many commissions as he could. And the most noteworthy of these midnight judges was John Marshall, a distant cousin of Thomas Jefferson, but someone who did not have anything in common with Jefferson as far as his philosophy of government. John Marshall was a staunch Federalist and had been Adams' Secretary of State. And so they're packing up the White House, and it's about time to go home, back to wherever it is that they live. They're about to be unemployed. And John Adams asked his outgoing Secretary of State, John Marshall, how would you like to be the Chief Justice? A job for life. John Marshall's like, yeah, Of course, I'd love to have a job. I was about to be unemployed. Thank you so much. Got an imaginary John Adams I'm hugging here, out of pure joy and excitement. And John Marshall is going to be a thorn in the Jeffersonian side for about 30 years. It's not until Andrew Jackson that John Marshall finally retires. And the single most important court case that John Marshall is deciding is one of his first, Marbury v. Madison. Now, Adams appointing these midnight judges was a little bit more complicated than you'd think. In order for Adams to appoint a judge, he had to make the appointment and the papers had to be delivered. The certificate had to be brought to these judges, and the person that did this was the Secretary of State. And so they got as many of these commissions out as they could, but they weren't able to get them all out. And so John Marshall, needing to get over to the Supreme Court to his new job, when the clock strikes midnight, Marshall gets these commissions that haven't been delivered, and he leaves them on his desk for his successor, James Madison. And with a little note, could you please deliver these at your earliest convenience? Could you please deliver these commissions for lifetime judgeships to people who hate you? And so when Madison gets to his desk and sees this, deliver these commissions to these Federalist judges. Madison thinks, well, don't mind if I don't. Take that, Federalists. And so, the people who don't get their commissions aren't very amused, although Madison probably thinks what he did was pretty funny. And so, William Marbury, one of these midnight judges, decides that he's going to take this case to the Supreme Court. And so Marbury goes to court, and he believes, this is John Marshall, this is my friend, this is my Federalist buddy. Of course he's going to side with me. And Marbury cites a provision of the Judiciary Act of 1791, which said that the Supreme Court could issue a writ of mandamus to the executive branch. And this writ of mandamus, coming from the same Latin root as mandatory, mandate, that the Supreme Court could tell the executive branch, you have to do this. Yes, you do. No questions. And so William Marbury wants John Marshall from the bench to tell James Madison, little Jimmy, that's what his wife called him, you better deliver those commissions. Well, what happens? Little Jimmy Madison says, why don't you make me? Well, there are three branches of government. The legislative branch, which makes the laws, the judicial branch, which judges the laws and hears disputes concerning them. A judge is a guy with a hammer that wears a robe and writes something once in a while. There's only one branch of government that can make me, and that is the executive branch. And so Marshall is in a bind, because if he tells Madison, you deliver those commissions right now, or no dessert for you tonight. And if Madison just crosses his arms and says, no, then that makes the judiciary branch, as Hamilton wrote in the Federalist, the weakest, the least harmful of any of them. That's not what Marshall wants. Marshall wants to build the federal judiciary into something powerful, into an equal partner in the government. Now, of course, this is what the Anti-Federalists had been afraid of when they opposed the Constitution in the first place. But John Marshall is the architect of the federal judiciary, and he sees that trying to win a short-term victory, trying to win the battle, is not where the ultimate victory lies. The ultimate victory lies in winning the war. And so what John Marshall says is that, yes, the Judiciary Act of 1791 does enable the Supreme Court to tell the executive branch what to do, to issue a writ of mandamus. But I find this to be in disagreement with the Constitution. It upsets the separation of powers that's outlined in the Constitution. So therefore, the Judiciary Act of 1791 is unconstitutional. Now, what Marshall has just done is nullify federal law. The same thing that Jefferson had done 5 years earlier through the Kentucky legislature. And so this principle of nullification, Marshall says that this is the prerogative of the Supreme Court to review laws that are brought before it, and if they contradict the Constitution, to declare them unconstitutional, as Jefferson would have said, void and of no force. And so in this, Marshall concedes the battle. Sorry, William Marbury, you'll have to find a real job. But in conceding the battle, he wins the war because he establishes the Supreme Court as the interpreter of the Constitution. Keep in mind, there's nothing in the Constitution that says that the Supreme Court should interpret it. The framers were naive enough to think that the government would always abide by it. There's nothing in here. Oh, if the government doesn't abide by this, turn to page 32. Nothing. And so there is this tension between the Jeffersonians and the Federalists. Who gets to interpret the Constitution? Do the states, as parties to the Constitutional Compact, get to interpret it for themselves? Or does an agent of the federal government, the federal judiciary, interpret them? Which, on one hand, why should all the states be able to decide for themselves? That sounds like chaos. But then again, the concept of judicial review, which is the Supreme Court's authority to overturn federal laws that it finds unconstitutional, what we have here is an agent of the federal government determining the federal government's powers. So this government created by the Constitution ultimately determines the extent of its own powers. But it's what we have. It's what we've gone with today. When there is a constitutional question, it's taken for granted that this needs to be brought before the Supreme Court so that they can decide whether it's constitutional or not. So the practice of judicial review is not something that's written in the Constitution, but it's something that has become part of our small c Constitution, part of our governing tradition, something that we've kind of made up as we've gone along. So let's review this real quick. Let's compare John Marshall, the Federalist, with Thomas Jefferson, the Republican.
When it comes to federalism, the proper relationship between the states and the federal government, John Marshall preferred a strong central government, just like Alexander Hamilton had. While Jefferson was a states' rights man, he believed that government should be closer to the people and that the federal government should remain within limits. Now, this is partly because Jefferson was a strict constructionist and believed that the Constitution's powers were strictly limited by the Constitution, whereas Marshall tended to be more of a loose constructionist. Of course, so did Jefferson, sometimes in little bits and pieces when it benefited him. Marshall loves the bank. It's one of his favorite things in the world. And we already know how Jefferson feels about the bank. Not too crazy about it. Jefferson was partial to agriculture. Got a little green marker there. Showed a little bit of agrarian virtue. Whereas Marshall, as a Federalist, tended to favor commerce and the budding manufacturing sector. When it comes to who interprets the Constitution, Jefferson, in his Kentucky Resolution, asserted that the states should interpret the Constitution for themselves as parties to the Constitutional Compact, whereas John Marshall in Marbury v. Madison asserts the authority of the Supreme Court to interpret the Constitution.
Marbury v. Madison is not Marshall's only decision. Let's take a quick look at a few of his other decisions. McCulloch versus Maryland and Gibbons versus Ogden. McCulloch versus Maryland is a case of the Bank of the United States versus the state of Maryland. The Bank of the United States had established a branch in the state of Maryland, and the state of Maryland had decided to tax the bank. The bank was doing business in the state of Maryland. The state of Maryland should be able to tax it. The bank goes to the Supreme Court and says that Maryland should not be able to tax us. We are an agent of the federal government, a constitutional agent of the federal government, and we should be exempt from state taxes. Now, Marshall has a huge dilemma on his hands, right? I've got, on this hand, a state, and on this hand, the national bank. Now wait, that's not a hard decision. Oh, the bank, of course, I'm a Federalist. And so, in McCulloch versus Maryland, Marshall decides on the side of the bank and says that a state cannot tax the bank because the bank is part of the federal government's legitimate powers. Under the Elastic Clause, not that it actually appears in the Constitution, but it is a legitimate power of the federal government, seen by me as a loose constructionist, therefore the state may not tax. Because, as Marshall wrote in his opinion, the power to tax involves the power to destroy. God forbid a state destroy such a great institution as our lovely national bank. Marshall's other major decision is Gibbons versus Ogden. The state of New York had granted a monopoly to a steamship company run by Robert Fulton and Ogden. And so they had their steamship company and they had a monopoly, transportation. Now, Cornelius Vanderbilt and Gibbons had started a competing steamship line. And this steamship line was headquartered in New Jersey. And this steamship line brought passengers from New Jersey to New York and back and forth. Well, the state of New York said, hey, we've given them a monopoly. And so Ogden and Fulton, they say, we've got a monopoly. They can't come into New York and do business. Well, John Marshall takes that as Constitution, goes to Article 1, Section 8, and he sees that, hey, actually, I don't even need to be a loose constructionist here, because it says here in Article 1, Section 8 very clearly that one of the powers of the federal government is to regulate commerce with foreign nations and among the several states. Interstate commerce is a delegated power to the federal government. And because Vanderbilt and Gibbons are involved in interstate commerce, commerce between states, then this New York monopoly cannot stand in the face of interstate commerce, which a state cannot regulate. So although Marshall doesn't need the Elastic Clause in this case, he is still deciding against a state and deciding really a pro-business decision as well, because if states start granting monopolies and build up walls toward commerce, then the economy can't grow, which that is a concern of the Federalists, that economic growth should be more important than states' rights.
All right, let's play a little game. Let's pretend these guys had Facebook accounts. We're going to look at John Marshall's Facebook, and we're going to go down his wall a little bit. And let's use what we've learned in Marbury v. Madison, McCulloch v. Maryland, and Gibbons versus Ogden as guides. And looking at these comments, let's decide if John Marshall would like or dislike the following items. Now go ahead and put your thumb here in the neutral position. Get ready. The elastic clause. Okay, let's see. The Constitution has posted on the wall. Necessary and proper. Ooh, I think John Marshall would like that. Yes, I was correct. I designed the game. I should be. Jefferson's posted. Resolved that the several states composing the United States of America resolved that the several states composing the United States of America by a compact under the style and title of a Constitution for the United States constituted a general government for special purposes, delegated to that government certain definite powers, reserving each state for itself the residuary mass of right to their own self-government. Sounds like states' rights to me. I don't think John Marshall would like that very much. Let's see. And again, I'm correct. How did John Marshall get that dislike button and I don't have one? Alexander Hamilton, Facebook mobile user. I could see him on his little phone all the time. Every power vested in a government is in its nature sovereign, which are not precluded by restrictions and exceptions specified in the Constitution, are not immoral, or not contrary to the essential ends of political society. That sounds like something John Marshall would really like. Unfortunately, really like is not an option, so Marshall's just going to have to like it. Madison. Let's see what Madison has to say. That Jeffersonian Republican. The powers delegated by the proposed Constitution to the federal government are few and defined. Those which are to remain in the state governments are numerous and indefinite. Ugh. All right, Marshall, not too crazy about that. The National Bank, an institution of primary importance to the prosperous administration of the finances and would be of the greatest utility in the operations connected with the support of the public credit. Well, yeah, the federal government has the ability to pay the debts of the United States, and the bank would help that. Necessary and proper? Sounds necessary and proper to me. Yeah, John Marshall loves this, but that's not an option. He can only like it. That's the end of our game. Stay tuned next time for the trials of the Jeffersonians.